we're going to get into contracts and business formation and some of those meaty pieces, but we want to make sure that we're all working from the same level of knowledge, and that is really copyrights. That's really what we're working at. It's the building across the street, right? The copyright is not only the photograph that I just took before I walked into this building, but also the mural itself. Whoever the artist was that created that mural has a copyright in that. And really, we have copyrights all around us. You have on your, and I hope you'll take some of the material with you, we have some flyers here that are printed by the CBCA. These are all protected by copyright, whether they registered them, and we'll talk about registration or not. As soon as this was reduced to a flyer, it was protected by copyright. The one thing we did hear from Dave Ratner, for those of you who were, had the privilege of hearing him talk this morning, copyright's not really common sense. There is some common sense, obviously, in everything. But just when you think common sense will take you all the way through there, you get hit in the head and you find out something went wrong. And I'm fearful for saying this because we're being videotaped, but I'm going to go ahead and try it anyway. This is a story that was relayed to me that hopefully will illustrate this point. It's about this person who dreamt in threes. All night long, it was 3 this, 3 llamas, 3 kids, 3 everything was flowing through his head. He wakes up, he's at the office, he's the 3rd person on the agenda at the board meeting. Everything is just 3, 3, 3, 3. After he gets off work, he goes to the horse racetrack. He walks up, he looks up, he's at the 3rd window. He pulls out all of his money, $33.33. So he bets on the third race, then the 3rd horse. He's there at the race. At the last turn, there's 3 horses that are contending, and of course, his horse finished 2nd, right? Which is good for him. He's in the money. So it's no gambling tips here provided by CBCA, but just because we think it makes logical sense is not going to necessarily carry you all the way through. And we're going to talk about some of the missteps and some of the common myths and things that go along with copyright. We had a wealth of artistic abilities that people just shared with us just a moment ago. We had visual artists, we had sculpture, including ceramics, we had music. We have a lot of artistic talent here. And what I'm going to tell you is when we're talking about copyright, it'll apply to all of it. There are some nuances, like with music, what copyright is held here and it's held here, and there are all sorts of different organizations that you have to negotiate with if you want to get the whole thing. And if you want to do something with film, you have to deal with some other organizations and some other groups, and that's all well and good. But just to understand what copyright is, I think we can talk about that. So I was really disappointed in some of you. I didn't see any doodling going on with Dave Ratner's speech. He's really good, but I was really hoping somebody would be doing some kind of doodling. So I'll do some doodling right there. And I don't know if you can see this. Can you see this from the back okay? No. All right. So this it's awful, right? This is a copyright at this moment in time. Why? Because there was some spark of creativity. Some spark of creativity here. And it's reduced to a tangible medium, a piece of paper. And that's really all you need. You also have to be a human being. We'll talk a little bit about that, but I think we can all qualify, even lawyers qualify as human beings, so we're good to go there. And you say, Dave, that is the worst piece of art that I have ever seen in my life. My kids' art from preschool that has been on the refrigerator is 10 times better. That's fine. We're not judging. We do, but we're not judging today. But in terms of copyright, that's all we need. I am the author of this, so if you say, boy, I love that, I'm going to put it on a t-shirt, you can't do that without my permission. Now, in the story of, and I'm going to call it a monkey, it's not a monkey, it's more more refined term for it, but there was a photographer in Indonesia. He was there to take landscape photos. He set up all of his equipment. He's in the middle of nowhere, so he could walk away. Unlike if you're in downtown Denver, you leave your camera equipment, you walk away, and guess what? Your camera equipment might not be there. In the middle of Indonesia, taking landscape photos, his camera equipment wasn't going to go anywhere. But when he came back, he found that what we're calling the monkeys, one of them had picked up one of the cameras, and some of the others were hamming it up for the camera. I mean, just like a 3 or 4-year-old might be, making the goofy faces and having these just remarkable set of photos. And the question was, well, who owns the photograph? Who owns the copyrights in the photos? Well, we still require you to be a human being, so that's why I'm allowed to use that photo without having to express permission from the photographer, because you need to. The monkey does not own the copyright. You laugh. It actually went up to the Court of Appeals. PETA filed on behalf of the monkey to say that we think the royalties should be placed in trust, and PETA will take care of making sure that it's distributed correctly. And you even had some kind of the most bizarre arguments you'd ever hear in a Court of Appeals argument about whether they actually have the right monkey or not as the one that's taking the photographs and also for. As of now, you still need to be a human being. But it's really easy to have a copyright. You might have heard about patents and how expensive it is to get a patent. It could cost $10,000 and up to get a patent. You own it as soon as you reduce it to a tangible medium. If I pull out my camera here, my sophisticated camera here that came with courtesy of the good folks of Apple, everybody smile. I've now taken a picture of you, and I have a copyright in this image. Why? Some spark your creativity. My camera angle, I wasn't trying to just, okay, I just did a little bit higher camera angle than you might expect. Wow, spark your creativity. It's reduced to a tangible medium. It's on my camera somewhere. I don't know how to get it off my camera, but it's on my camera. Someone else can take a look at it. If I was to do some sort of dance steps, which my wife has threatened to divorce me if I should ever do any kind of dance steps out in public, because I will thoroughly embarrass myself, and she's absolutely correct as she is about most things. And then I stop, there's no copyright in that. Now, because we're being recorded, we could go back to the film and say, well, the copyright is there, but let's put away the cameras and all the things. I know paparazzi wants to take lots of photos of me, but putting that aside, there's nowhere for us to be able to see what I actually did, which would have been horrifying. There would need to be therapy and things involved there. Thankfully for you, none of that is, that's not included in the price of the CBA ticket, I don't believe. So the point is, as long as it's reduced to a tangible medium and we have some sort of spark of creativity, we're good to go. Our whole economy seems to have changed to borrowing someone else's works when it comes to art. And that is a fine line. That's how I put my kids through college, frankly, as to where that line is, as to what we can borrow and how much and what we do. The buzzword that pays, the lawyers love to use, is it transformative? You hear that word until you almost get sick to your stomach. But really, I mean, what did we do to that image? Is it different? Is it commenting on something different? Are we using it as a criticism, as a parody? All those types of things. And we're going to talk about a few more factors as well. But if we were just to take my image, for example, and then just print it and slap it on a canvas, we haven't really done anything, right? If we make that into a sculptural work and we add considerable flair to it, that might work for us. If we make a slavish copy, so for example, there was a famous what I'll call appropriation artist, and he saw a photograph of a well-to-do family with dogs, and they're all sitting on the bench, and he thought, fantastic. And he sent it off to Italy and said, make this into a sculptural work. And then they said, hey, we have some questions. What should we do about the nose? And the comments back were, make it exactly like you see in the photograph. That was a problem. The court said, you didn't do anything. You didn't transform it. You're not commenting on anything. That same appropriation artist learned the next case that he needed to do something. So when he got sued the next time, he was saying, I'm making a public commentary, not that photo, a different photo. He's smart enough to, I can't do it again. Fooled me once. I'm going to take this other image and I'm going to use, which was an advertisement, and I'm going to make this into something that I'm going to sell for $1 bazillion. And he got sued again. He said, I was making more of a commentary about how we spend our money and consumerism. And court said, okay, we'll buy off on that. So, and it wasn't a slavish copy. There were some differences and some changes, and so there is that fine line, and hopefully we'll talk a little bit more about that. But it only protects the expression of the idea. So the first person who says, I'm going to show an image of a cowboy behind barbed wire and kind of a Western scene, or let's use a better example. Let's say I am the very first person to walk along the cliffs of Maine, and the water's crashing and spraying up, and there's a lighthouse and the seagull. Now, how I'm the first person to see this when there's already a lighthouse there, put aside, suspend your belief system for a moment. And I take a picture of that when the sun is going down. Fantastic picture, right? I don't own the monopoly on that image. All of you could go to Maine in that same place, stand where I was saying, and click that same picture. We're all allowed to do that. Now, if I have wild game there and tigers and llamas and things that have no earthly being to be in Maine by that cliff there, and you bring all those animals in there, maybe there's something for us to talk about. But as far as what the idea is, copyright won't protect ideas, only how we express those ideas. If I want to be a writer and I'm going to talk about kids who discover that they have magical powers, and they go to a school to learn how to use their magical powers, and while they're on their way, they have to fight these forces of evil. What does that sound a lot like? Harry Potter, Hogwarts, all that kind of stuff, right? We could write that book. We just can't say Harry Potter, Hermione. We can't lift passages from the book. We can't use these fictional characters that J.K. Rowling has developed. We have to develop our own characters. But the idea surrounding the story, that is still something that we can use. So when we're talking about what we can borrow and not borrow, we can certainly use the idea. It's how we express that idea that gets to be a little bit tricky. So, and we're not, and again, when I said we're not judging, maybe that's because I'm terrible at this, but whether this is considered art or not art has no bearing as to whether that's a copyright or not. It may help. I mean, the better we are at it may actually help our ability to stop others from using or for saying it's similar in style or different things. Fictional works versus non-fictional works are going to have different levels of protection. But in determining whether there's a copyright or not, we are not judging whether it's any good. We can all agree that this is probably not very good. And what do I own? At this moment in time that I reduce this to a piece of paper, I own the copyright. But what is it that I own? Dave's already explained it. Those of you who were here for the earlier sessions, I'll summarize his entire thing that he said right here. What I own is I own this piece of paper at this moment in time and the copyright. If I was to sell this to, what's your name? Sunita. If I sell this to Sunita, Sunita owns that piece of paper with that lovely piece of art that I have put together, but I still own the copyright unless we've signed something where I say, I am also giving you the copyright. If I just sell you this thing, you own the thing. So remember that when those of you who are artists and you're selling your works, remember you still own the copyright. What does that allow you to do? Well, you can make more of these things. You can reproduce them. We have to use bigger words, right? We can make more of these things. We can make derivative works. I'm sorry, remind me your name? Pam. You have a name sticker on there. You don't have to remind me. Would you add something to this for me, please? So she added this little curlicue up the top here. Now, she wouldn't have had the right to do that, except I said, "Hey, would you do this?" Right? I gave her permission. But I am the sole one who has the right to make what's called derivative works. I can add to this, I can build upon the original work to make other things. To distribute it, I can sell it, right? Perform it. This is going to have a hard time on its own, just performing on its own, right? But we have other works, performing arts works. Those that have the exclusive right, the right to display it, visual arts. You might have seen the pictures of the Mona Lisa with the mustaches and kind of the funky different things. If the Mona Lisa was developed let's say 5 years ago, you wouldn't be allowed to do that. But because it's what we call in the public domain, nobody owns the copyright in there, we can add those funny little things to the Mona Lisa pictures as well. All right, so collaborate. Pam and I just collaborated in developing this. So now what? I own this, she owns this. Anyone own a house? Okay, a few of you. So if you own a house with a spouse or a significant other, does one of you own the bathroom and someone else own the hallway and the kitchen? No, you own the whole house, right, together. Same thing with the copyright. The fact that I did 80% of the work, thank you very little, Pam. The fact that I did 80% of the work doesn't mean that she has any less rights to the copyright. Unless we say otherwise, we both own the copyright jointly. And we own it just like we do in our house. She doesn't just own this piece. It's meant to be one in a single piece. If we have music, someone might have done the composition, someone might have done the lyrics. We intended for those two things to come together and form one copyright, one single work. And in that case, we own it jointly. Now, there may be contracts that would say, well, you actually get X percentage and I get X percentage, but that's a contract. Contracts, we can do whatever we want to as long as it's not immoral, illegal, and things that will embarrass us. You can be embarrassed. How long do they last? A really, 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 really long time. That's a long time, right? So how long do they last? They last for, let's keep Pam out of it for a moment. She's dreading that she's even involved in this in the first place, this piece of work. But let's just start with my original work. How long does it last? It lasts for my lifetime. I plan on living for quite a while, just for the sheer fact that I have kids and I want to annoy them when they get in their older ages. So my lifetime plus 70 years. That's a long time. We can thank Mickey Mouse and the Disney folks, 70. Now, the fact that Pam and I did this together, we're going to measure it in the same way, but we're going to look at both of our lives together. So Pam is going to outlive all of us because she's in tremendous health. She takes good care of. She didn't eat the cookies. I'm going to eat all of that stuff that you guys don't eat later. So she's good. So we might measure it in her life, whoever's life. It doesn't matter. If this was, well, we can get into some of the technique. It can last a little longer depending on if this was a work for hire or not. But for our purposes of what we're going to talk about, let's think about it in terms of a life plus 70 years. Make sense? Long time? And we can all thank Walt Disney Corporation for that. Yes?
So is that why the Mona Lisa isn't copyrighted anymore, or is that something different?
Well, Mona Lisa, so the copyright laws in the U.S. started in 1909. And they've gone through different quirks. There was an initial 28-year period at one point during our copyright life, and then if you had a small window of time to renew it, and you had to use the Circle C and all of that kind of stuff, and you didn't meet any of those formalities, you're a host. You lost your copyright. We still use that Circle C. Everybody know what I'm talking about with the Circle C? We still use that Circle C, but that's more to let everyone else know that there's a copyright that's involved here. Don't rip me off. You're on notice that there is a copyright here. It's just another way of reminding people that not to rip us off. But you don't have to use that for copyright purposes.
But the Mona Lisa, you started to say.
I'm sorry. The Mona Lisa is in the public domain because it was made a very long time ago, right? Different set of laws, right? We're in Europe. France. France had early copyright laws, and Mona Lisa would have been, I guess I've never really thought about it, whether the French copyright laws would have protected the Mona Lisa for some period of time. That's a good question. I don't know. It's not protected now. We can do whatever we want with it. Registration, incredibly easy. I tell people that unless you're doing computer software, some other film, definitely an issue. But for visual art, for the most part, we can do this very easily. I tell people you can drink your coffee in your bedroom slippers and register it online. It's a simple form to fill out. It's very inexpensive. The range is between $35 and $55 for most works that we would be talking about. And for, we had a photographer in the group, yep, here. You can register, I believe it's 750 images all at once. One of the annoying things is you have to give each a name. It could be number 1, number 2, number 3, number 4. I'm not going to count 750, and all of us will be grateful for that. But you can register groups together for the same fee. So it's a fairly inexpensive process, and you don't need a lawyer for the most part to work on that. That's something you can do on your own. You go to copyright.gov, say what you want about the government. They actually do some things right. Frequently asked questions will answer most of your questions and walk you through the process. They'll show you an application and go line by line and tell you what it is that you need. Author. Are you the author? Yes, no. Who is the author? And you put that in there, publication date, and they just walk you through the whole process. It's pretty easy. So that is something you don't need a lawyer for, and you can do on your own easily. So if we have inventions, how do we do things, business methods, that's what we're talking about in terms of patents. When we talk about brands, famous brand, McDonald's, logos, what can Brown do for you, those are all trademarks. And those are they're signifying to consumers, hey, this is associated with some good or service, some company that's involved here. Copyright, again, is the expression of an idea. So now sometimes your logo can be both a copyright and a trademark. So you might have some design elements to it. Copyright's not going to protect short phrases. So so you would want to have some sort of artistic element to it. And maybe you have some very stylistic version of your name. Maybe you have maybe you're a carpenter and you have a little house design along with the name of your company, and it's all incorporated in one. That could serve as a copyright. Yeah, and it's one of those things, no harm, no foul type things. What registration will do, you say, well, Dave, why would I even bother to register? I didn't read that slide fast enough, or you didn't leave that slide up there long enough. You told me as soon as I made this that I own a copyright. So why on earth would I possibly want to register the copyright with the Copyright Office? A couple big reasons. One is you're putting the world on notice. 2, if you should ever need a lawyer, to get a lawyer involved. So let's say Pam and I put this together and we find out that Brianna, not that she would ever do that because she's been through these, she understands copyright, but Brianna says, that's fantastic. I'm going to slap that on mugs. I'm going to make a fortune on Etsy. And this will be great. And Pam finds out, hey, Brianna is ripping us off, Dave. In order for us to, if we send her a nice letter saying, thank you very much for being fans of ours, but this is how we make our living and all those nice, the nice track doesn't work, and Brianna says, see you in court. The only way we get into court is we have to have a registration. Also, if you want to get a lawyer to take your case outside of CAFTA, you're going to want to have a registration done beforehand. Why? Because there is some ability to get attorney's fees. In the U.S., if we go to court, we do our thing in court, each side pays their own way for the most part. In copyright law, if we have our copyright registered before the infringement or within 3 months of publication, let's just say before before Brianna starts infringing, we went ahead and we're smart. Pam says, Dave, we got to get this thing registered. Let's do it now. And we do it. And then Brianna starts ripping us off. We can go to the court and say, not only did we have our a little C and notice, and we told Brianna that it was our copyright, judge, we want our damages, and we want attorney's fees. Now, why is that important? Because Pam and I don't have any money, right? We aren't the appropriation artist who's selling works for $20,000, $30,000, $40,000 a pop, right? We're still working on it. At some point, we'd like to get there, but we're not there yet. We can't afford a lawyer charging $330 or $320 or $1,000 an hour. We can't afford that. But we might be able to get an attorney to take it on a contingency fee. Contingency fee means the lawyer takes a percentage of whatever it is that we win. We might be able to convince a lawyer to do it if there's some possibility that the lawyer knows they may get the attorney's fees from the court. It doesn't happen often enough. And it's also great leverage, right? When I write the letter to Brianna saying, Brianna, we're glad you're fans. Please stop. And she says, nah, I'm not going to stop. My next letter is not so nice. I say, Brianna, you really have to stop because we have a registration. We're going to sue you for the damages. And you may pay for our attorneys. And by gosh, our attorneys aren't cheap. Brianna may say, crud, I don't want to pay for my attorney and their attorney. Maybe I will stop. If you're dealing with businesses, that's also very persuasive, right? When they're trying to make some of these business decisions.
You said within 3 months or something like that, or at what point are you able to go back and register?
So we tell people register early and often, okay? So as soon as Pam and I made this and we said, we're done, we should register.
And then somebody ripped you off.
Right. So then we still have the ability to go ahead and go after people who are infringing, but we have less available to us. So for example, if they start ripping us off, a year after we published this, so we started selling this to people. Remember, we sold this to Sunita. She was gracious enough to buy our very first number. And of course, we numbered ours. Number one. She bought number one of our print lot of 200, and then a year passes, and she starts ripping us off. We can still sue her, but we can't. One, we're not going to get attorney's fees. The other thing that registration does is it allows you to get a certain amount of damages, irrespective if you've ever made a dime selling these things. So let's say I don't have this long history of being able to show that this is what I normally make for my works. I start with $750. I say, Judge, I have a range from $750,000 to $30,000 I'm going to get, and they call them statutory damages because I've registered this and she's infringing and the timing all works. If we do it outside, I have to prove that, hey, Sunita paid $1,000 for this. Thank you. Sunita paid $1,000 for this, and other people would pay more. We just gave her a sweet family discount, kind of friends and family discount kind of thing, right? And if you're in the film industry, you can also register this before it's even completed. And then there's some other steps that are having to do that, but that's more because you're worried about the film getting out there and then being released and that kind of thing. Dave mentioned the Hope Obama poster in there, so I wanted to sneak that in there. The whole idea, we had a photographer, an AP photographer who took a picture of President Obama, and George Clooney was there and some others, of course, and we had the Hope Obama poster made based on that. And this goes a little bit to the question that you raised of how much borrowing can you make. And we were very excited about this case because we thought we might get some guidance about this. We didn't get the guidance from this because the Hope Obama poster, Shepard Fairey, lied. I will tell you, do not lie to your lawyers. And for Pete's sake, do not lie to a federal judge. I work for a federal judge. I will tell you, if you made him mad, were not truthful to him, it was going to be awfully hard for you to get back on the other side. Shepard Fairey lied. the wheels fell off. We didn't get the guidance that we wanted. We had some other cases like this where you have some of these. We had a photographer took this picture. We had a mayor up in Wisconsin who was very, he wanted to shut down an annual party, kind of a big festival mainly of college students. And they printed up these, the kids printed up these shirts saying, sorry for partying. And the mayor got very petty and upset and bought the rights to the photo that this was based on, and he sued. And the court said, give me a break. Really, all that's been left by the time you strip everything out is basically his smile. The reason I'm going to put this chart up here is not so that you go through all these factors or memorize anything, but just really to understand, looking at the purpose and character of the use. We're looking at the nature of the work, the amount that was taken, the effect on the potential market. These are all factors that the court's going to take a look at when we're making those decisions. When I said that I can put my kids through college on this issue of whether what's been transformative and considered fair use, and you really can. And the courts don't necessarily agree with each other. The Second Circuit and the Ninth Circuit don't necessarily agree with each other. But one of the things we do want to take a look at, I've heard, if I only take 10% or I only take 20%, then I'm fine, right, Dave? No copyright infringement. And the answer is maybe, it depends. And the example is Gerald Ford, we know from history lessons, was a president at one point in our time, and he wrote a book. And one of the magazines got a hold of the pre-publication of the book and printed a chapter, a small chapter. They printed a chapter. And when they got sued, their defense was, hey, this book is huge. You could hit somebody over the head with them and they would die. It's so big. We only took a small portion of this. Well, the portion that they took from Gerald Ford's book was, hey, what was the process of going about making your decision of whether to pardon Nixon or not? And the court said, other than his mom, who else is going to buy the book for all that other stuff? People are going to buy the book for that chapter. The reason people would be interested in this book is, why did Gerald Ford decide to pardon Nixon? And you took the heart of what it is that we're talking about. If we're talking about who's on first, what's on second, I've said no more. We all know what I'm talking about, right? Who's on first, what's on second? We know that whole little shtick, right? That's part of a larger movie, if you will. But that's the heart of the movie. That's the only reason that anybody's interested in the movie. Let me come back to you. You had sort of a tentative hand up.
Why did it not work out for you with the Shepard Fair case for you to get what you wanted?
Oh, because he had to settle. Because he lied to the court. And so he had great lawyers for free from Stanford, if I remember right, as part of their fair use project defending him. And he said, look, I didn't use that photo. I used some other photo. And bloggers comparing all sorts of photos, right? Bloggers have nothing else to do at the time. I'm a blogger too, I guess, so maybe I have nothing useful to do with my time. But they discovered that, no, liar, liar, pants on fire.
And the issue was there that it was owned by Alternative Press, that photo?
This was an Associated Press photo. Taken by a photographer, and that had its own issues, right? Does Associated Press have the rights to it, or does the photographer? What was the contract between those two as to who owned those rights? But that's yet a whole nother story. But once it came out that, yes, this actually was the photo, and he's made this big lie about it, he's kind of done. His credibility is shot, right?
Even though arguably it could have been transformative.
This still could have been transformative. If he would have just said, yes, this is the photo that I used. He didn't have to lie about that. But he did. So, so we didn't really learn much from this case other than don't lie to a federal judge or to your lawyers. And the Associated Press got some money. But, the same factors is what they're going to look at. What was the purpose and character of this use? How artistic was it? If fictional is going to be more protected than non-fictional works, nature of the work, its amount worked. and what is it that's the effect on the market. But I want to turn it over to the esteemed Dave to talk more about the contracts, and I'll interrupt him because. Yeah, you know it,
That's how
right?
this works?
Yeah, exactly.
Well, I mean, I guess if there are any more questions, because you guys have covered a lot of good stuff.
Yeah,
here.
I'm sorry. I did.
Yeah, sure.
In respect to your collaborative fine piece of art, if
Thank you.
you decide to put it out there as a teaching tool, i.e. paint by number, does that change anything with the registered copyright?
So if we decide that we're going to sell this so that people can recreate this in terms of a paint by numbers type, let's say we have more colors and things involved, does that change things in terms of, it would probably be a derivative work, but because we have the sole right to make a derivative work, we can do that. We might want to register that derivative work as well as a separate work as well, so that we make sure we get the full copyright protection.
It looks better that direction.
Right. The one thing I did skip over, if you don't mind,
No, of course not.
about owners, for example. Let's say that I hired Pam to put this in, that I am not capable of putting this in as well as she does. So I hire her to do that. And she's not my employee. She doesn't work. We're not working for Hallmark Cards where we're employees, but I hire her. Then who owns this? I'm probably going to have a contract with her saying that we are independent contractors and I want her to assign this work to me. Why? Because she probably does still own this. Think of it in terms of you're a business and you hire someone to create a website. The person who created the website owns the copyright in the website. If you ever get crossways with your web developer, they could pull it all back and say you have no more rights to use this. If Pam is an employee, then the company, and I'm an employee of the company owns this. We don't own this. If this is our job. Now, if we're janitors, our job is probably not to create this. If we're computer programmers for a gaming company, maybe. So you get some ownership issue questions, yeah.
Where do things fall into place as far as a brand using music, spoken word, public work to sell their product, and then the artists or the owners of the work coming into play as far as their cut or being involved with stuff like that?
Let's say I'm going to make a commercial and I want to hawk my company's goods and services, and we hire you.
Well, you don't hire me.
I don't hire you. I just
use the
find something off the internet. You're in trouble. I'm in trouble. You're not in trouble. I'm in trouble if I just go ahead and start using it. Now, there are sources like Creative Commons. There are lots of sites out there that will say, you can use this for free. But you want to read through those terms. Use it for free. Do you have to give them credit for using it? Is it for only non-commercial purposes only? Some places will say you can use it for free if you give it credit, but you can't make any money off of it. Or, like in the software side of things, you can use it for free. You don't have to give us any credit, but if you use it, anything that you create is now part of for free for everyone as well. So if you incorporate something for free, now your product is free. So you want to look at some of those things. Yes?
So, I don't know if you've been to recently where they put their car in the urban jungle and have a mural behind it.
Yeah.
Do those mural artists have any rights to that?
They do. A lot Banana Republic, a lot of the companies that want to be, hip and cool, like filming in front of graffiti, street art, and they've been sued. And there haven't been a lot of outcomes on those as to who wins and loses, because they've pretty much all been settled with some exceptions. But tattoos are certainly a hot area, and street art graffiti is a hot area of copyright. But generally, yes, the artist still retains that. So if I have that in the background, I'm going to be in trouble unless I get permission from the artist. Yeah.
What's the appropriate way I'll just say, I've had a car dealership that's taken a picture in front of a piece that I did.
Right.
And has promoted their product in front of the piece. What's the proper way to engage with that before you're just like, hey, you're getting sued?
Oh, yeah, and it's usually not that step immediately, oh, I'm going to sue you,
Right.
right? It's usually, hey, I'm glad you're a fan of our work. I want you to know that I am the owner of that work. It's protected by copyright. You've used this. I want to start a dialogue with you. You know, let's talk about this. I tell people, I go into court. I love it, but you don't want to be in court. It takes up not only a lot of your money or somebody's money, it takes up a lot of time. So having that dialogue is that way. It's for the folks that say, I don't care.
So the difference is I don't go to court, right? So this is a great, this is a really fun exchange, fun for me anyway,
Yeah.
because it gets out of two different perspectives. Because the thing is, Dave says you start a dialogue, and then where I see that is, and that results in a contract. It results in a license where you're going to have, hopefully, you have an agreement where the dealership says, you're right, you own that, we want to use it, we'll license it from you, we'll pay you a certain fee, whether it's a royalty or a flat fee, and we have a license contract, and then we avoid the court. Right, so I think it's a great answer to the question, which is,
That's a good transition
there
too.
you go, right? You're not going too far.
I won't.
Don't go too far.
I'll be the guy in the back of the room yelling at you.
That's fine. But I mean, that's the thing is that you're absolutely right. It's actually something, when I was up here doing the presentation for the Creative District for the Cacophony of Creatives last fall, this came up a lot because one thing that lawyers are great at doing is scaring people, right? We're great at talking about you're going to get sued or you're going to have to sue someone. But the reality is that's not hopefully what's going to happen all the time, but it is what we're trained in, right? We're great at worst case scenarios. That's what lawyers are awesome at because hopefully what we're doing is avoiding those situations, right? And so, but you're absolutely right to ask the question, and hopefully if we do our work well, we don't end up, spending too much time and too much money in court. And hopefully we get an agreement out of it, and that can be mutually beneficial. The dealership gets to use your work, and you get to get paid for it, like you should.
You can also ask that his name be credited.
Well, his name should be credited regardless, right?
Receive credit for the argument.
Yeah, so that's part of the negotiation, right? What kind of credit we can get. Interesting, one of the things that I've learned in these negotiations is, different things are important to different people, right? And especially when it comes to our art, it's like, is it more, there is the side of it that is the business side of it, which is getting your name out there and making sure you get the notoriety of it. But there's also the financial side of it, is getting paid for it. There's a lot of those pieces of the puzzle. Credit is important though. I regularly get the question, I'm sure you do too, which is, oh, well, I'm going to use this other person's art or this other person's work, and I'm going to credit him, so that's fine, right?
No.
All right. How about this one? I'm going to use someone else's work, but I'm not charging for it. I'm just going to give it away for free, so that's okay.
Well, that's what Shepard was doing a while with that poster.
Part of it, yeah. Yeah, part of it. And the thing is, what's interesting is that copyright protection, like the copyright protection exists regardless of where that use is for profit or not. When we're evaluating, when we have to go to court and we're doing an evaluation of whether it's a fair use, one of the things we'll look at is, did it affect the market for the original? Did we make money off it or not? But that's only one of the things we look at. So the fact that, I'm making a mixtape and I'm going to distribute that mixtape for free doesn't mean you can just go mash up other people's work without getting the permission. So,
Just to illustrate,
Yeah.
Just to illustrate that point about, artists have different wants or needs. Sometimes we'll go back and we're having that dialogue with, let's say, the car company. And we'll say, here are two options. We're fine with either one of them. You pick one of these two options. One is more money-based and one has something else that hopefully will further the artist's career in some way. And we'll say, pick the money version, just pay us a straight amount of money, or get us involved in whatever thing that we think is going to advance the artist's career, if that's what he or she really wants. So, it can be either or.
Sure.
With the original art that you did, if Pam came along and saw the original art, but she added to it or altered it, how much alteration happens before it becomes her art? Or is it always your art and she's...
So Pam and I are, since we are the joint authors, let's say the third person wanted to add something to that, we are the ones that they'd have to come to, because we have the exclusive right to make what's called derivative works. Now, we had a question earlier, I'm sorry, I can't see your name.
Sheila.
We had an earlier question from Sheila about how much do you need to change to get to that point, and that's, when we have those 4 factors on the list, there's just not this nice, clean, easy answer. I can say that just going from 2-dimensional to 3-dimensional isn't going to be enough. But if you go from 2-dimensional to 3-dimensional and we're commenting on something, or it's a parody, or it's used for some other completely different purpose, as the Garcia pictures, posters, were used for more of a commentary, and there was this tiny little thing that couldn't be used as a poster. So you went from this poster to something that was more of a critique, art critique, and you wouldn't buy this little tiny thumbnail as a replacement for your poster that you had.
So a little bit of judgment on it.
There's a lot of judgment.
It's a really common question we get is how much do I have to change it for it to be mine? How much do I have to change it before I'm not ripping off? Before it's not an infringement. And there is no bright line rule. There is no 3% or 30%. It is a case-by-case analysis.
So are the words derivative and transformative the same? I was beginning to think that they're different.
They are.
So transformative, and I got to thinking when you gave the example of taking your fine art and turning it into a color by number kind of a thing. I guess I have 2 questions that are sort of intertwined. Did you say that if a color by number version or thing, painting thing, was produced using your artwork, that only you had the right to make that derivative because it's the idea of that? Or did I get that wrong?
Not because of that.
Could it come up, what if somebody besides you and Pam came up with the idea of, okay, let's turn this into a paint by number thing? What is the law there then?
Yeah, so again, we're not protecting ideas, but if you're using that piece of art, and the only thing you're doing is making a paint by numbers piece of this, this line,
Right.
paint this line in blue and paint this line in red.
Right.
You haven't really done anything. You're just using the original. And so then you really should come to Pam and I and get our permission to use it.
Okay, so somebody else could do it, but they'd have to get your permission to do that.
Right.
And so is that considered that's a derivative?
I would say you could consider it a derivative.
Oh, okay, so really derivative would be making something substantially different about it.
Yeah. Do you have a different thought?
I think that it's the 2 words. It's important. It's understandable that those 2 words could be confused. So what I would say is that a derivative work is just something based on original. And the reason derivative is really important for copyright is because it's one of the exclusive rights that you have as a copyright owner. So when you create a piece of art, you have the exclusive right to distribute it, to reproduce it, to perform it, to display it, and to create a derivative of it. So as an owner of that piece of work, the only person who's allowed to make a change to make a derivative of it is the owner, is the copyright owner, unless he gives permission to someone else. But if someone else, if a Shepard Fairey comes along and makes a derivative, makes something that's based on the original, how different is it? Is that derivative transformative? Is it sufficiently transformative so that it's now no longer a derivative and it's a fair use? Is that?
This isn't this is an oversimplification. If you say I'm inspired by this, that's different from making a derivative work. You can look at something. Shepard Fairey can say, I looked at that photo of President Obama, and I was inspired because I saw these different colors and thoughts and lines and different things, and what I ended up creating was simply an inspiration based on the photograph. You arguably have a different outcome.
So Dave, I've been teaching art for 43 years, and I used to think that if a student took a photo and changed 5 pieces of it, that they didn't put the barn here and they didn't have the tree there and they added the bird here and they added the cloud there, because that was what I think I had been taught. Then I got the feeling from reading and trying to teach them about their copyright rules, that wasn't enough. If somebody could look at the photograph and sense that there was a similarity between these two, that they were infringing on copyright. So I was telling them that they shouldn't be copying anything if you can use that photo of a barn as a reference to help you come up with an image for a barn or whatever. But that's not what I'm hearing you saying, so I don't know what to tell my students. So I mean, I'm supposed to go back into my classroom, and I was hoping I would be able to come up with it. Say,
These guys wouldn't have
know what the copyright, because I have. I mean, I've Googled copyright law, I've looked at the copyright, and I thought what it was saying is that if you can attribute it, if you can identify that this image is from this source, and mostly it's from National Geographic kinds of things. People copying photographs of celebrities and doing that kind of stuff, fan art. So I sort of need to know what is the right answer on that, and maybe there isn't none, so they can't use any photos then.
The phrase of case is it substantially similar or not? And, we're saying all these different things, but really, if you put this in front of your peers and you said, are these two things substantially similar? And they all say yes, you have an answer, right? It's probably yes. Because the judge is just like all of us, right? They're going to look at this. The jury's going to look at, is it substantially, we'll have experts and do all this stuff, but ultimately when it comes down to it, it really is a gut. Is this substantially similar or not? Was this inspired, or is this complete and totally different, really? Or is this, the moon is yellow here, the moon is blue there, but they're all kind of in the same composition, it's the same feel, same style, same, listen to your gut is what I tell folks.
Well, and I think,
To say that I thought I knew the answer when you said, but in a different situation, if it's inspired by, and I thought, okay, I know the answer, and now I'm afraid to say what I think is the answer. If it's inspired by, then is it, which is it? Is it infringe? Is it copyright infringement or is it not?
It was substantially similar.
Is it that? Is it inspired by plus? It's substantially different.
What creative talents have you brought to bear? Is what I ask when they say, how much can I borrow? I'm like, what is it that you are bringing to the table that's different than what's already been done with the stuff that you are borrowing? What are you combining and doing different things with that it gives you a different feel? It's a different emotions, a whole different style. It's like, you could see some of the things, I see the barn in there, but the barn is over here and it's together with a cityscape, and so now I'm having a commentary about rural and urban life going on that I didn't have in the original.
That helps, I can teach that.
well, here's the thing I think that actually is a reasonable takeaway to your point about moving 5 things, is that there isn't a rule that you can just say, if you move 5 things, it's okay. If you change it 30%, it's okay. I know that makes it hard to teach because we all want rules that we can easily explain. But for better or worse, copyright law doesn't work that way. For better for us because it gives us something to do. And I understand it's frustrating though, and this is what we hear from clients all the time. Yeah. Right? It's just that it's how close is it, and unfortunately there just isn't a, if it's this much then it's over the line. So.
Can I ask? I'm asking this Dave because he's the music guy. We've been talking about visual art, and I know I have heard about examples in the music world as well. Can you talk a little bit about that, and then, and I guess it's also applicable to cover bands.
Okay.
So, can you speak to that a little bit?
We can talk about this in terms of music. So, one of the interesting things that's gone on with music is that the way that we make music has changed. Technology has changed all creative works, right? I mean, whether it's the way you make a painting or a photograph and share these things. So music is now made much more digitally, commonly. So we have a lot of examples of music that is digitally created, so electronic music that isn't made with an instrument, right? And what has happened is that we have a lot of music these days that is made from other pieces of music that arguably is in violation of the copyright law. What has happened, however, is that the owners of those music rights have realized that suing their customers isn't a good strategy for downloading the music, so that didn't work very well. And suing other artists also doesn't work very well because the artists are also the clients of the record labels and the publishers. So in fact, what's going on a lot of times in music is that you're hearing music that is arguably an infringement, a copyright infringement, but it's not getting pursued. So there's kind of the letter of the law and the enforcement of the law. There is still plenty of enforcement. There's still plenty of lawsuits going on. But there is if we look at the standards for what was when we originally started with digital reproduction of music, when like the Beastie Boys were getting sued because they were some of the first people to do that, versus now what you see in mainstream music is commonly done. Again, that's unfortunately not a simple legal answer because we've got two examples that are getting treated differently. And I think one of the things Dave was alluding to earlier is you can have the courts will disagree, right? And so we don't have, again, bright line rules for this. Separate from that is cover tunes. So I'll expand I know a few of us are musicians in here. I'll expand on Dave's copyright lesson a little bit to explain that there's two copyrights in every piece of music. There's a copyright in the composition, so that's the words in music, what's written down. There's a completely separate copyright in the sound recording, what we call the master. So I can write a song, I'm going to own the composition, and then Bree can go and record the song, and she's going to own the master. And that's a completely separate copyright. And all she has to do is have what's called a mechanical license, a license from me to make a cover of my song. Thing is, that mechanical license is what we call a statutory license, so the statute requires me to give her that license. I'm not allowed to say no. Once I've put my music out in the world, anyone else can go re-record it. And this is different than all the other stuff we've been talking about, so I'm sorry to confuse you. But again, this is what keeps us employed. So cover tunes allow for, once the music's out there, anyone else can go cover it, can go make a recording of that composition. You get a mechanical license, and you pay a mechanical license fee, which is also set by statute, so that anyone can go make cover recordings. You just have to pay the proper fee. Yes, ma'am?
If I'm a student of art, and the teacher says, here's some pictures, paint the pictures, and I paint one of them, and it's almost as close as the original. I sense I cannot sign it because I've taken somebody's picture, painted it.
Well, signing it has nothing to do with it, right? I mean, whether you sign it or not, it's your creation, right? You created this work, and
I took it from a photo that was not mine.
the question is whether it's an infringement. The question is whether, so someone else owns the photo, right? Whoever took the photo likely, or their employer, owns the copyright in that photo. As the owner of the copyright in that photo, they have a set of exclusive rights, including the right to make a derivative work. And your painting could be a derivative work of the photo. That's the Shepard Fairey example. Shepard Fairey took a photo, he made a painting of it. Was that painting a derivative, a violation of the rights of the copyright owner, or was it a separate work, a transformative work that stands on its own? And as Dave said, unfortunately, we didn't get a ruling on that. So we don't have oh, well, there's an easy example, we know the answer. And as he was just saying, it depends on what you added to it. How different, if someone looked at the two, how different are they? How much creative expression did you add?
How good of an artist you are.
That's, I know, if I painted a painting of a photo, it would look nothing like it because I'm horrible at painting, right? But that is part of it.
Well, this particular case, I can't.
I call the work still pretty, even though it doesn't look like the original.
There you go.
It's not as good. So, but I didn't sign it because I was confused.
I don't think sell it, I still.
Well, so
Sign it, go sell it?
signing it has nothing to do with anything. Because here's the thing. Dave's beautiful artwork that he's been showing around all day today, he didn't sign it. He owns the copyright in it. He created it. Signing it does not affect copyright. The only part, the only significance of signing it is if you add the circle C, because the circle C is the circle C with the date, with the year of creation and the name of the owner. That's what we call a copyright notice. It's not required, but it's suggested, so you put the world on notice that you own the copyright. But whether you sign a work, I mean, think about it this way. When I take, what Dave came up here with his phone, he took a photograph. He owns the copyright in that photograph. He didn't sign it, right? Bree writes a piece of music. She owns the copyright of the music, records it. She owns the copyright in the recording. She didn't sign it. It doesn't, the signature is insignificant. And what's tough about this is the copyright exists as soon as you create it. So you painted that photograph, you own the copyright in it. The question of whether it's an infringement, you created it, it's an infringement or it's not. Now you said, I'm not going to sell it, I'm not going to show it to anyone. So if you were my client, you came to me and said, Dave, I'm really worried. I painted this photo and I'm not going to show it to anybody. I'm not that concerned, right? I can't tell you, oh, it's legal and do whatever you want. But part of our job as lawyers is to advise our clients of the risk. The risk of you painting a painting of a photograph for your personal use that you're never going to show to anybody, the risk is pretty low. I'm not going to tell you it's legal. I'm going to tell you the risk is pretty low.
I would just say I wanted to sell it.
Oh.
Mostly what I do is give them away, actually.
They're still distributing. You're still distributing, and distribution is an exclusive right in copyright.
What I do is,
Yeah.
let's say somebody's having a fundraiser, I will give something to a fundraiser, okay?
It's putting, okay.
But now what?
Now, so, set of exclusive rights. The owner of the photograph owns a set of exclusive rights. That includes the right to publish, to distribute, to perform, to display, to create a derivative. Okay, so you've now taken the photograph, you've created a derivative of it, and now you're going to distribute it. You're now violating two of the copyrights, or two of the exclusive rights. Now, again, I don't know whether your work is significantly transformative and whether it's an infringement, but whether or not, if you are distributing it, okay, you're putting, whether it's for charity or not, you're distributing it, right? So there's all kind of steps in the process, and it's funny because this goes back to, what we can teach our students, right? It's like, it's just not that simple. And it's great because these questions are awesome because it makes our lives a lot easier to teach you or to explain to you, yeah, this is complicated stuff. You might have to talk to a lawyer. Sir in the back, yeah.
In the Creative Commons.
Creative Commons is a wonderful thorn in the side of copyright lawyers. So has anyone else heard of Creative Commons? Familiar? Okay. So Creative Commons is an alternate copyright scheme, okay? Because copyright, by nature, the copyright statute is somewhat black and white. It says, you own it, no one else can use it without your permission. Creative Commons says, well, it started with software. It started with open source software. That's where Creative Commons came from. Because people were creating copyrighted software that they wanted to share. How do we get it out there? Right? And so Creative Commons created this licensing scheme. And so basically you can say, I'm not going to use my traditional copyright or copyright protection. I'm going to assign a basically universal license to it. And I think there's 4 different licenses there. Yeah. So there's 4 different types of licenses that have been created. The license terms have been dreamt up by Creative Commons. And so you can say, I'm giving, the public is allowed to use this, but they must give me attribution. That's one type of license. And so Creative Commons, we can use works that are labeled with Creative Commons licenses according to the terms of those licenses.
So let's say someone starts to infringe on a Creative Commons license. Is that then the point where you engage a lawyer and say, here, this is, how I've licensed this, can we get this person to stop? Let's say, I don't know, I make something that's, a digital file that's used to make an object that has some use, like a tool. And I want that to be freely used, but then my neighbor starts to sell them. Or they use, a machine to make it to sell it.
Dave, have you litigated Creative Commons?
Not Creative Commons, but something very similar. And in fact, it's one of these issues where they bought the license from an entity like a Creative Commons, and so they were stuck with those license terms. If they had bought it directly from the person who created the work through their website, they would have had a different license, which would have been fine. And so we didn't litigate it, we just had them go approach them and go buy the proper license and do some mea culpas, and it all works out. But it's very important to know what it is that you are getting in terms of those licenses Dave's just explained.
Well, I think one of the things, so let's think about it this way. So one of the things I was going to talk about today was is contracts, okay, and licensing. And so when you own a copyright, you can grant someone else some of those rights through a contract known as a license, okay? So in the same way that you could directly license, you could say, I create this tool and I'm directly licensing it to you to use for free, and you would be anybody, right? To the same extent, if someone violated that license, you would go to them and you would say, we had this contract, you broke the contract, what are we going to do about it? Am I going to sue you? Are we going to negotiate? Are we going to come up with a deal? And so the Creative Commons is kind of like, it's a license agreement, it's just a license agreement you're granting to the general public, okay? And to the same extent, if we violate a contract, there are going to be repercussions. So if someone violates your Creative Commons license, there are going to be repercussions, just like if they had violated a direct license, a direct contract. Okay. Yes, ma'am.
One of you mentioned earlier something about tattoos, and I love Dr. Seuss. I've been looking at her speaks. So, in the case of tattoos, she paid the artist to create something that's inspired, obviously, by Dr. Seuss.
We got a law school exam right here. Okay. So let's start with the tattoo and not the Dr. Seuss part. Okay. So here's the thing. You hire a tattoo artist to create a work of art, to create a copyrighted work, arguably. This is the same as you're hiring someone to paint a mural, you're hiring someone to take a photograph, you're hiring someone to write a song. They're creating a work, okay? And the issue is, whoever creates a copyrightable work owns the copyright. So the issue is, did we now hire a tattoo artist that now owns artwork that is on your body? But the one thing that's kind of important to remember is that it doesn't really matter what type of art it is still art, it is still a copyrighted work as far as general rules go. And so I frequently run into this with photographers, right? Because you hire a photographer to photograph your wedding, okay? I see this all the time where the wedding couple says, well, we hired you and we're gonna take these photos, we're gonna put them on Facebook, we're gonna make an album, we're gonna put a print on the wall. And the photographer says, no, I own those photographs. You can't just go put it on Facebook without my permission. Doesn't really make sense to the average wedding couple who doesn't know copyright law, because I paid you, it's me and my family, I own those photographs, they're mine. But by what the law says, that the creator owns the work unless there's a contract to the contrary, unless there's a writing, which there can be. You can have a contract with your tattoo artist that says, you're creating this artwork, but I'm paying you for it, I'm going to own it. This brings up a type of contract called a work for hire. So I love seeing nods, because that means we've heard of work for hire. It's great. We're off to a good start. Dave talked about it earlier. He said if you are employed and you create a copyrighted work for your employer, and it's created within the scope of your employment, so it's part of your job to create these things, then your employer owns it. It's a work for hire. You are hired by your employer. You create a copyrighted work as part of that that job. Your employer owns it. Another way work for hire exists is with a contract. So copyright can be transferred with a contract. And if it's not an employment situation, if it's an independent contractor situation, like wedding photographer, tattoo artist, right? They're not our employees, but we're hiring them and we're paying them. We have something in writing, we have a contract or part of a contract that says, this is a work for hire. I hired you to do this, I own it, I paid you, whether I paid you in, whatever I may have paid you, I paid you, and that transfers the work. One of the tricky things about copyright is that a copyright transfer has to be in writing. So the law generally allows for verbal contracts. In a lot of ways, we can, you're going to sell your car, I'm going to buy your car, we agree on a price, we shake hands. We've got a contract. We have what's called a meeting of the minds. We can have a contract. doesn't have to be in writing. It's still enforceable, except in copyright. There's a few areas of the law, copyright being one of them, where the transfer of a copyright must be in writing. So you have to have, and whether that is work for hire or whether it is I painted this painting and I'm going to sell you the painting, and with the painting I'm going to sell you the copyright so I can't make any more copies of it, you will own all the rights, that has to be in writing. So these are situations where contracts are going to intersect with the stuff we've been talking about today, because we do need to have it in writing. I mean, I'll take it one step further. I will always encourage anyone in any sort of business deal to put it in writing. I mean, it's just, contracts are really valuable because oftentimes our memories of the deal we made aren't that good, especially when a lot of money is suddenly involved and maybe one person wants to make a lot more money. So any sort of deal that is going on where you're hiring someone or there's any sort of transaction, it's really worthwhile to put it in a contract. And a contract doesn't have to be full of legal mumbo jumbo. Right? Lawyers are trained in this language of legalese that's really hard to understand. It's really annoying with the whereas and the hereins and all this type of stuff. And people think that this is now how we have to write to have an enforceable contract. And as lawyers, we've been taught that, right? I mean, we learned it in law school. It's how judges write. It's just, it's part of the, you know, it's part of the institution. However, an enforceable contract does not have to be in legalese. An enforceable contract has to be clear. It has to show a meeting of the minds. It has to properly identify the parties. There has to be an exchange of something of value, whether it's money or something else. There's parts, there's things, factors, there's ingredients we have to have an enforceable contract. But it doesn't have to be with legal mumbo jumbo. And I'm certainly always going to encourage someone, if you ask a lawyer, should I hire a lawyer to write a contract? I think you know what my answer is going to be. Right? I mean, I regularly have clients or just folks in general say, well, I download this contract off the internet. There's a lot of crap on the internet, excuse my language. There's some good things on the internet, right? And whether it's contracts or whatever you're finding on Reddit, there's good things on the internet, there's bad things on the internet. The problem with contracts I see downloaded from the internet is that they are not specific to the situation, right? A partner at the law firm I started at a law school said a contract tells a story, right? The story is unique to you. So even if we use the example of the wedding photographer, right? We have a contract for someone to photograph an event. It's not complicated, but there's going to be special terms for when the person's going to show up. Do they have to show up at 9 a.m. or can they just get there right before it starts? What are they going to deliver? Are they delivering the raw files? Are they just delivering prints? Are we delivering a CD? Are we delivering on a flash drive? What happens if we cancel? Is there a cancellation fee? Can we reschedule? There's all these things. And so the downloaded contract off the internet that's a page long may not include all of those things. And so a lot of times it is a simple deal and we can have a simple contract. I'm always going to say, I'd rather you have a contract that you write than no contract at all. But I'd rather have a professionally written contract if it's possible.
So you pointed about Dr. Seuss and copyrighted information on tattoos.
Oh, back to Dr. Seuss. Forgot about that part. Yes.
So is that copyrighted material, and is it the tattoo artist that you're
That violated the copyright?
Put it on the person, or is it the canvas that bought it?
Yeah, no, it's definitely more likely to be on the artist that created the artwork than on the canvas that bought it. Yeah.
This is a really specialized question, so if it's too specific, I'll try and catch you afterwards. But I don't create art in the sense of artists who paint or dance and stuff. I created an after-school arts program.
Okay.
And I'm trying to figure out if I don't know what to do with it because I created it when I was still employed as faculty at UNC as part of a club that I created when I was faculty, and then as part of a course requirement that I created the assignment. The uniqueness of the program is how I integrate Anyway, there's pedagogy, there's something. Where is my first step? I mean, I'm thinking, do I need to go, I mean, I'm thinking that I need to talk to UNC about my emeritus status, and yeah, I just need you to just suggest some first steps, I imagine.
I cannot provide legal advice. Nothing I say today is legal advice, nor what Dave Ryan says. I'll back him up too. Well, yeah, I mean, look, whether to talk to your employer depends on the relationship, right? Again, what the standards of the law say that if you create something that's copyrighted for your employer within the scope of your employment, then it's owned by the employer. However, what we're talking about here doesn't sound like it's like copyright as much as it may be, I'm not sure what. So
Well,
it's
what might be the program, the components of it are a pedagogy created by another faculty with wide-reaching impact, and then my component is a unique cultural perspective that no one has combined those pedagogies together. I mean, the pedagogy with this particular perspective, so that's my unique.
So is the pedagogy a piece of art? Is that the-
Well, no, it's actually, I think it's more as the pedagogy copyrightable. Is it, and and so obviously we know copyright has to be fixed. Like Dave said, it has to be fixed in a tangible medium in some way. So that's part of it. I think we should probably talk about this separately because it's getting a little deep into the weeds, and want to make sure we're not losing everybody else's. Yeah, sure, of course. The whole employer part of this brings up a piece of this that is, I think, important in just our work in the arts. I don't know, would it be helpful to take a break and stretch our legs? Or is everybody feeling like, yeah? Okay, let's take a 5-minute break and then we'll come back, bathroom, water's up here, and then we'll start back in like 5 minutes. One thing that is related to a lot of the things that we've been talking about that kind of underlies all of this is the business side of things, right? Is that, to the extent that we are professional artists, it's a business. And it's hard because our art is our creative work, and it's something we may not feel is like a product. It's not something we feel like is packaged or marketed, but it is still to the extent that we are selling it or licensing it or selling tickets to a show or anything like that. It is a business. And so we want to kind of look at it that way because it makes it much better in the long run. It is not at all it's not meant to take the value out of it in any way. It's that there are certain things that we do to properly run a business that'll help protect us down the road. And one of the things I often get from people is, well, it's just me, right? So I'm myself. I don't need to be a business because if I own a business, there's no difference between me and the business I own. And that's actually not the case when it comes to the legal aspect of things. So, a business is a separate person under the law. So we have, a business could be a corporation, it could be an LLC, a limited liability company. There's a lot of different types of businesses, and we form these businesses by filing a document with the state. That's the first kind of step in the process. Anyone have a business, LLC, corporation? Cool. How many of us hired a lawyer to help form our business? Right. Thank you very much. So no, and here's the thing. It's not that you need a lawyer to do it. It's that there's a legal aspect to it. When I was managing bands, long before I went to law school, I filed my articles of organization with the state of Colorado that said I had an LLC. I said, cool, I've got an LLC. I have a piece of paper. That doesn't make a company. But the question that underlies all this is, why do I need a company? Right? What's the value of this? If it's just me, if I'm a solo artist, why do I need to have a company? And from the lawyer's perspective, from where I stand, where I sit, I guess is more proper, it's about liability protection. So the thing is that in operating a business or just being out in the world, we are subject to potential liability. And that happens in a variety of ways. There's all sorts of, I told you, lawyers are great at worst case scenarios. And so I can tell you all the ways you could run into liability in just kind of operating your creative business. The reason we have an entity Like I said, I'll use LLC or a corporation as an entity. The reason we have an entity is so that the entity can be liable for what we do, and we are not personally liable for what we do. So since that entity is a different person under the law, it has rights and obligations, and it can take on its own liabilities that'll be separate from us, and we build this wall in between our individual selves and our business selves, basically. And that wall protects us from being liable. So if something goes wrong, they can't get through that wall to our personal lives, our personal assets. And that has a lot of value when things go wrong. So, and I think a lot of us are saying, well, you know, I'm just a musician. How could I be liable? Thank you. That helps. So that was not planned, by the way, but that's exactly right. That was on cue. So the thing is, so easy example being liable is if someone else comes along and says, you stole my song. That song that you recorded, that's mine, you stole it, I'm going to sue you for copyright infringement. So a lot of us may think that's unlikely to happen. Okay, because we have control over it. We're going to say, I'm not going to write anything that's remotely like someone else. I'm not going to paint anything that's remotely like someone else. I am not going to commit copyright infringement. Okay, what you're doing, what you can control, you will keep out of the harm's way. You'll stay out of liability. There's things we can control. You're a musician, you're playing a show, and the stage catches on fire. The stage collapses and falls on someone, because this, unfortunately, has happened at a number of festivals over the past few years. We've had stage collapses due to storms or even not, and people have been killed. Well, when people get injured or killed, in our very litigious society, they or their heirs hire lawyers to go and sue people for those damages. And they will sue everybody under the sun, everybody who's related to it. So the stage collapse example, they will sue the festival, the promoter and the presenter, they will sue the staging company, they will sue the security company, and they will sue the artist. They're just going to sue everybody. And so in that situation where you didn't do anything wrong, but suddenly you are subject to liability, much better for your entity to be liable than for you to be personally liable. The entity has its own assets, right? So to the extent, Dave said here, who owns a house, right? So to the extent you own a house, you don't want them to be able to sue you and come after your house. Your entity will have assets. It may be equipment, it may be instruments, it may be supplies. So it does have assets, but it's not going to have your house, your car, your yacht, and your plane, whatever else you own, is not going to be, sorry? College fund, sure. I mean, all these, your personal bank accounts, right? Your investments, whatever it is, that stays on the personal side. The entity side only has the business assets. So this is the legal reasoning or the legal argument for, hey, we should have an entity, even if you are a sole proprietor, you're the only person running that business. But certainly, in the arts, an easy example is for a multi-person entity, a band, right? You've got multiple people involved in a arts endeavor, right? So those multiple people form that entity together, and that entity serves as a real great vehicle for owning the band equipment, okay? Signing the band contracts, things like that, that are really activities of the entity. There are things we do to form entities that are more than just filing that one piece of paper that I did when I was a band manager. So we do file that piece of paper, but what we want to do is we want to create, we want to take other steps that substantiate the entity so it's more than just a piece of paper. These are things like getting a federal tax ID number and opening a bank account, right? So the bank account has its own assets, right? And all the money that comes in hopefully you're making a lot of money in your endeavors, all that money goes into that bank account, and then your expenses for that endeavor are paid out of that bank account. So we do that. We have internal documents. An LLC has an operating agreement, or a corporation would have bylaws, and this is the governing documents for the entity. And I know this stuff sounds super boring, and it's just one of these things that we do. This is where the copyright stuff is fun. We can talk about Shepard Fairey, we can talk about apes taking pictures, but unfortunately there's a business side too. So I get the boring stuff here, right? But it is really in these steps that we take help form an entity, formalize the entity so that it provides that liability protection. Situation, in the event, we take the example of something goes wrong, some liability is created, and there is a lawsuit that ensues. Okay, and what's going to happen is, especially, you may say, well, they're just going to sue me. I'm a solo artist. I may have this LLC, but they're just going to sue me personally. And what's going to happen is you're going to go to court and you're going to say, Judge, this is not me personally. This is my business, right? And they should only sue my business. They shouldn't sue me personally. And the judge will say, well, show me your business. Well, that's why this one piece of paper isn't very helpful, because then all we have is a piece of paper. If we say, here's our bank account, here's our books and records, our ledger, here's our operating agreement, here's our meeting minutes. I mean, there's all these things that we do, certainly tax returns, although an LLC doesn't have its own returns, but all these things that we have to substantiate that we have this separate entity. So it provides that, that liability protection. The questions that I usually get around this are about taxes, and I am not a tax attorney. So one line that my clients are really sick of hearing me say is, you should ask your accountant about that. But an accountant is a member, is a valuable kind of member of your team, right? Is a valuable person that you bring on to help make sure that you are getting the best tax treatment that you can and working properly within the confines of the entity. Yeah.
Is there an organization similar to this?
Is there a CAFTA for accountants?
That accountants know artsy kind of businesses?
Ah, so there are accountants that know artsy types of businesses, yes, absolutely. And and honestly, whatever your business is, you want to work with an accountant and a lawyer who understands your business, right? I mean, I think in general, it's just like, you're not going to hire a fine artist to paint your house, right? I mean, yes, they're both painters. House painter and a fine artist are both painters, but not the same thing. So, so it is helpful to really find someone who does know that type of work, and it's an absolutely reasonable question to ask. I always tell, when my friends are out, say I need to hire a lawyer, I'll try and give them some referrals, but if it's something I don't do, but I'll say, interview that person. Ask them all the questions you want to ask. I mean, you're hiring a service provider, so they should be able to answer those questions. But you're absolutely right. You want them to know your business.
Two questions. Speaking of the value of a LLC for protecting the artist, is it also true in reverse, where the artist wants to take legal action against something else? Is it helpful to have an entity, or does it really not matter if the artist is acting on his own behalf or on the behalf of his company?
It depends on what that action is, because the entity can act if it is the entity that has been wronged, or if the entity has a right of action. So it really does depend on what the situation is. If the entity owns the copyright, sure, then certainly, and there's an infringement of that copyright. Even if the entity has been licensed, let's say the entity is a record label. Okay, so the record label has been licensed the rights to the music is infringed. A lot of record contracts will give the record label the right to go and pursue infringements. And I actually see a number of license agreements where the licensee, the company licensing in the copyright work, does have the right to enforce the copyrights.
So then the second part of the question is thinking about the Creative Commons again. Somebody's got their image out there, they're fine with people using it because it's been used for good and love and peace and all that, but then, and they don't enforce anything, that was an infringement with other people appropriating it, but then they have somebody use it for something they don't approve of. Can you really pick and choose, or do you need to be consistent about enforcement? I
think it's a tough argument to make. It's a tough argument to make that that I'm fine with all these other infringements, but I'm not okay with this one. I don't know if you've ever run across that, David, in any sort of case.
We take the position, we don't have to stop everybody, but we do need to be diligent. So it's not like we could go dormant for 10 years and then all of a sudden start up. But we don't have to sue everybody or send cease and desist letters or nice letters to everybody.
Or nice letters.
Arbitrary. In other words, if I'm arbitrary about who I'm going after versus inconsistent, that's a different thing.
It's a consistency in logic, right? For example, so political purposes, right? In every campaign season, we have plenty of examples of artists who don't like some politician using their music for that campaign rally, but other politicians it is okay, right? And that gets into more than infringement because there's other things that are attached to that. But that's an example, I think. So, yeah.
Kind of a blurred lines question. Let's say Juan Valdez, the singer, is hired up to play for Mayfest or something here at the block party, right? Yeah. And he goes to the Moxie, plays his set, gets done playing his set, still at the Moxie, supporting other bands, does something where he jacks up the Moxie. Where do you separate being liable and not being liable anymore, even though you're still there for the gig?
Well, if it's an individual taking action and violating rights or causing damage, that individual is going to be liable for his actions. So you're saying if the individual has an LLC and the LLC is performing. So the LLC was probably not engaged to do the things after the show. But I think that that artist is creating personal liability by depending on what it is that he's doing and what the conditions are, is creating personal liability by acting outside the scope of what he was engaged to do.
And vice versa as well? Like from the other way around, let's say the artist slips and falls or something like that.
Right, because the artist is personally damaged. However, there's the angle of, well, he's personally damaged, now his furnishing company, the company that he does his business through, is no longer making money because he can't perform, and so there's damages to the LLC as well. So these things, there's always these different angles on these things. There's always these kind of wrinkles in it. And I think that, there are a lot of tricky things that come out of the thing that I hear about from clients about single person entities, single person LLCs or corporations is, well, it's just me, so why do I need it? Right? Because what's the difference between me and the entity? And that's the whole liability thing. With multiple person entities, it also serves the function of helping manage and operate that group. And as far as in the arts, a band is the easiest example, right? And having that entity helps us, and the documents behind it, so the operating agreement or band agreement behind that entity, helps us with everything from the ownership of the recordings, to the ownership of the band name, to what happens if somebody leaves the band, to what happens if or can someone get kicked out of the band. And we're dealing with all those things as, through the entity, right? So it provides us a vehicle for having partnerships, right? For having multiple person endeavors. It does that as well. Sorry, you say something?
I'm just going to answer
Yeah.
your comments to his question. The entity and the individual will be carrying their own insurance. They have a good insurance agent, and that sometimes determines who their liability is to.
Insurance is a big part of this, regardless of entity. And it's something we were talking about this morning's session, that insurance, if you ask a lawyer if my client asks me whether they should have insurance, the answer is, of course you should have insurance. You're asking your lawyer, right? I mean, I'm always going to think about all the ways things can go wrong, and I'm going to tell you need insurance to cover it. I'm also going to tell you I'm not an insurance professional, and there's professionals who know exactly what coverage you need, and if they, and they should be, again, specialized to what you do. So your State Farm insurance provider may not have insurance that's specific to your particular creative endeavor. A great example of this is for films. Films, you need to have insurance to protect against someone claiming that you didn't get permission to put something in your film. That's just not that's just not a type of insurance that most insurance providers offer. So it is important to work with an insurance provider who has expertise and knowledge in your area. And all these things are about reducing risk. Because ultimately, I think that's my job as a transactional lawyer, someone who's helping get the intellectual property protection in place and get the LLCs or the entities formed and get the contract signed. It's about reducing risk. It's about helping clients proceed with what they're trying to do without being liable for things and not having their rights stolen or having their rights infringed, all those type of things. So these are all just steps in that process. Your question?
Yeah, on topic of bylaws, are you aware of, I I mean, I don't want to say like an open source boilerplate for bylaws. Do you have any recommendations on drafting bylaws that don't involve contracting a lawyer? I mean, maybe, you know, find someone who works but, like, let's say I just made a business just so I could have a bank account, right? And
Right.
have that legal tool. I'm not really concerned about the legal mechanisms behind it, but it seems like there's this requirement nonetheless.
So there is not a legal requirement to have the bylaws. It's just that it goes to substantiate the entity. So it basically is a way of saying, I have more than just a piece of paper. I actually have a company that operates according to these bylaws. It is very hard for me to recommend that you not hire a lawyer to do things like this. But you kind of get, you know, that's the answer you're going to get, right? And the thing is, and I can't remember if I said this earlier, that just the stuff that you find on the internet is very generic, you know. And look, to the extent that yes, it's generic for a single person entity, yes, it's just what does your entity do? Are you producing products or services? You know, is there any liability to the products? Is there, you know, do you have inventory in products? There's just so many things that are about how it operates. So that's why I think there's value in getting something customized for your use. But as I said with the contract, I'd rather you have a contract that you write yourself than no contract at all, right? So, yeah.
In addition to that, when you Google something for your industry, like bylaws, you know, sample bylaws for artists, read through them as best you can, because none of us really understand all of the legal jargon, but write in the things that you think should be included, cross off what you think shouldn't be, and then hire an attorney to review it, because that's going to be a lot easier than having the attorney create it, unless you have Dave, who probably already has it all set up.
I mean, well, you want to hire an attorney that's done it before, right? I will say, actually, I often find that it is quicker, easier, and therefore less expensive if I write it than if my client writes it and hands it to me and has me review it, depending on what it is and the client's experience and whatnot. But
Looking for something pretty basic.
right, which should be pretty inexpensive for me to do, right? So, I mean, one of the tough things, I mean, I think, you know, it is the astronomical expense of lawyers is no secret, right? And I will absolutely, I mean, this is how I got into this line of work, is because a lot of my band clients when I was managing bands couldn't afford a lawyer. I said, well, I can go do this, and that's why I do pro bono work through CAFTA, is because I realized that it's really that as artists we don't get paid very well in general, and as lawyers get paid too much in general. In the beginning, which part? As lawyers have more success, they get paid more. Yes, that is true. But as artists get, yes.
Get them out of trouble. Rich people have attorneys to keep them out of trouble. And that's why
It's a bit of a joke. Anyway, so I mean, I think the thing is that I'm not going to stand up here and tell you every single one of you has to hire a lawyer every time you touch anything legal. Like, that's just not logical. I totally get that. So we just have to place value on these things, you know, and see what, you know, where is our cost benefit. And so, you know, I'm not gonna say don't ever turn on your computer again, don't ever download anything from the internet, because, you know, it's not going to be good. It's just that you want to be able to know what you're getting yourself into. You gonna say something, Dave?
Yeah. You know, whether you write something yourself or you go to someone like Dave or I, you should be at least thinking about the questions of what it is you're trying to convey through this. And I think of this document as twofold. One is like the Constitution. How are we going to operate at a very high level, not day-to-day stuff, but at a very high level. And then the other is as a prenup. What happens when we get our, you know, proverbial divorce? Because you are entering into a relationship. It's just a relationship in a different form than you know, with your significant other. And if you can answer the questions that you would think of what would be in my Constitution and what would be in my prenup, when you come see your lawyer, you're going to be ahead of the game of most of the people that you will see. Dave will have other questions that he'll want to ask you and have his checklist, but you should be thinking about these things before you even talk to your lawyer.
Absolutely. Yeah, I mean, a lot of times, I can only speak from my experience and how you know, we operate things at my firm, but we always do a free consultation. We always say, yes, think about these questions, bring these materials, all that type of stuff, because we realize, you know, that really you just want to have you just want the answers, you want to have the protection, and that's ultimately our job. So, yeah.
So if you were to paint a perfect picture of when a lawyer or someone like yourself comes in to assist a creative,
Yeah.
what's kind of the ideal place?
It's funny because the typical question of, when should I hire a lawyer is yesterday, right? I mean, but for creatives, you're right, because a lot of us are, amateur artists or just doing it for fun or things like that, so there may not be as much of a need. I look at it as on a couple of different scales or factors, which is part of it is the finance, right? So the financial, what are you investing in this, or what are you making from it? What's your what's your financial stake in it? And I think another part of it is what is the risk that you're facing, or what is the issue that you're facing? Because usually, most of the time in my experience, there's something that motivates that phone call, right? There's something that motivates someone to think, I should probably talk to a lawyer. And then we can get into what is underneath that, because maybe that one thing is, I got offered a contract. I got offered some sort of deal, someone handed me a contract, and I thought, well, first of all, this is in English, I don't know what it means, I should hire a lawyer, right? And then it's kind of like, what is underlying that? Do we have to form an entity? Do we need any of that? Have we done our intellectual property protection as far as copyrights or trademarks or things like that? So there isn't really a one answer to that. But it does really, I think it usually is because something is motivating that thought. And I will tell you, I certainly would love it for everyone to come to me before anything goes wrong. That's not always the case, right? For whatever reason, it doesn't always go that way. I did, when I first started working with bands, I was doing a lot more band separations than band formations. Right, that just was, and I remember that the partner that I was working for at the firm said, and so what happened is we had these band separations, and the band would come in and they had no documentation, right? It was just they were like, well, we're gonna split up, and what do we do? Like, oh, jeez. So I said, if they had a band agreement to start with, that'd be so much easier. So the partner at my firm said, I've got this great idea. We're gonna do a band formation special. And we're going to do their operating agreement, and we're going to do their LLC formation, and we're going to do their copyright, and for $1,000. I said, if any band starting out had $1,000, do you think there's going to spend it on a lawyer? Like, it's just not logical. Right? That's not how it works, right? So we have to be realistic, and I think that is.
What is being realistic, I guess?
Being realistic is I think it's a cost-benefit analysis. Right? It's that, is the cost of this attorney worth the benefit, or am I willing to take the risk and not expend the cost? But however, we have resources like CAFTA, so if we can't afford the cost, we go through CAFTA. There's a much, much, much lower cost, so we have those options. Or, those type of things are kind of part of that decision matrix. So, yeah.
Really excited about your slide up there that says invoices.
Dave, it's all you, man. It's not my slide. You walked right into that one. Is that a contract?
Yeah, my point with this is that, who's ever sold anything? And whoever wants to sell something, right? If you don't do any contract, at least do something like this. You can, we've talked about all the stuff that's garbage on the internet. You can pull any kind of invoice off the internet and then just add some terms to it. So Dave's talked about, hey, make sure you keep the copyright in there. So maybe you say something in there. You're just reminding them that you, artist, still own the copyright. Maybe there's some the terms aren't necessarily important.
It says payment is due in 30 days, title will not be delivered and will not pass, retain full copyright, agreement by paying amount. Nothing specific, nothing that's so material.
The point isn't the specific terms.
Right.
But if there are terms that you want, you don't have to have a complicated contract. You can get one of these invoices, whenever you sell something, describe what it is that you're selling, give it a title, right? Put a price in there. Your bookkeeper will kiss you on the cheek or your forehead at the end of the year when you're trying to figure out your taxes and everything else. And you put some of these terms on there, that you want specific to what it is that you're doing. I don't know what your business is, what you're selling, to say, these are the terms that you absolutely should have. I'd love for you to say payment is due in 30 days so that when someone doesn't pay you, if you're not doing it right then and there, that you can knock on the door. It says sound buffer thing. You can knock on the door and say, hey, remember you promised to pay me in 30 days. Some things like that, whatever your business is. The point was just that you don't need a complicated contract.
Well, and I'll tell people, right, that's so the thing, a contract requires a meeting of the minds, right? We have to agree, we have to both agree that these are the terms that we agreed to. And so if it says, I'm giving you this piece of property, you're going to pay me this amount, you're going to pay me within 30 days, there's your contract. Sign on the dotted line helps, right? Then we have some sort of proof of it. But I tell people, you can use bullet points. Because if it isn't a direct sale, right? So if an invoice isn't really appropriate. But if there's some sort of, I'll use the example of the wedding photographer. Okay, so even if it's just, it doesn't have to be a long, complicated, it can be one page. Better one page than nothing, right? That just says the time, the date, the place, the cost, what you're going to deliver, when you're going to deliver it, all those basic things. And this is easy for me to rattle off because I do this all the time. Right? But if you think about kind of what is important, right? What you negotiate, and also think about, what could go wrong? They don't pay you. They say you didn't deliver on time. They say you didn't deliver what you promised you'd deliver. A lot of times, work with creative agencies or marketing folks or people who are delivering some sort of creative product where there's going to be a editing process, a review, a back and forth. So you're hiring someone to create a short video, okay? Well, the person who's creating that video is going to deliver you a video, and you're going to say, change this, change that, and change that. Okay, they go back and change it. They deliver it back again. Okay, I like that, but now change this and change that. Okay, how many times do we get to do that? Right? All the things that cause problems, to the extent that you've been doing this before, or you have friends that have, or you're in a group of people who do what you do, ask them, what kind of stuff do you run into? Where have things gone wrong? What have you fought with people about? And that's the stuff we put in our contract. Because the most common one is, I didn't get paid, right? That's why we're here. That's why we're talking about invoice. Because that's the most common thing that we as lawyers probably get is, in some way or another, I didn't get paid. But, I always say that, none of my clients have ever called me up and said, hey, nothing went wrong today. Right? That's not why we're here. Unfortunately, I'd love for my job to be that people tell me that everything was great, but that's not my job. And it's the nature of our work. It's why we get this kind of cynical worst case scenario perspective on things, because people call us when things go wrong. Part of the reason Dave and I and Kafta and Meredith are here today is to help you avoid those things, right? By a little forethought and a little planning and a couple things in writing, understanding the copyright protection, understanding rights and responsibilities, so we can avoid those things going wrong in the future. And then hopefully, you're only coming to us for the good things. You're only coming to us because I got this awesome offer, this great contract, this record deal, whatever it is. And then we're like, okay, you're going to get this deal. There's some real money here. We got something to work with. And then there's nothing to, there's not a conflict there. It's an opportunity. So I think that's kind of part of the way that we look at it. Yes?
Off the wall.
Uh-oh.
How hard is identity theft for creatives? Is it more complex than it is for regular business owner, or?
I think the issue that comes to mind from that question is not so much for creatives as it is for celebrity. So identity theft, if someone's stealing your bank account or your social or something like that, creates issues for anybody. It's when you have rights of publicity that are valuable, that there may be something to it, but you can't really, and I guess you can. Yeah, you can't steal. You can say that you're someone else. It's just not something that I can say that I run into every day. So
this is perfectly, and I was wondering, it seems very counter in what this discussion has been about intellectual property,
Yeah.
Creative, but the whole concept of tribute bands cover bands.
Yeah.
I pay, at Democracy, I have to pay BMI and ASCAP a percentage of my ticket sales versus, because of an arrangement that I've had with them. I'm still fighting a group called CSAC, because they want to charge, $5,000 a year between you and I, which is more than I can afford. So the idea is that these groups own these, they help these publishing groups own these things, but they don't control, or the artists themselves can't stop people from doing a tribute band or from performing their music live. And that, there is no laws against that. There's a band out right now called Led Zeppelin 2.
Yeah, so there is, so it's not that there's not laws against it, it's that the law provides for it to work that way. So ASCAP, BMI, and CSAC are, I think they come up every single time we do. I can do this presentation anywhere in the state, anywhere in the country, and this is going to come up. So you are not the only person suffering from ASCAP, BMI, and CSAC. For background, okay, so when an artist writes a song, they own the copyright in the composition, okay, the words and music, what's written down. As we've talked about earlier today, when you own a copyright, you own a set of exclusive rights. Those rights include the right to distribute, the right to duplicate, the right to perform, the right to display, the right of derivative work. So as I write a song, I own the exclusive right to perform that work. Perform does not only mean perform live. Perform means it is played over a loudspeaker to a group of more than 3 people that isn't your family, essentially. And what we created is a system where I'm writing music, it is being performed hopefully all over the country. It's in bars and restaurants and health clubs and elevators. My music is being played over loudspeakers. I cannot go to every bar, music, health club, and elevator to collect my licensing fee. So we created ASCAP, BMI, and CSAC. These are called performing rights organizations. What performing rights organizations do is they go collect the money for the performance of the artist's music. Most countries only have 1, we have 3, that's a whole other mess. These are actually, there are consent decrees with Congress for the creation of these organizations. ASCAP and BMI are nonprofits. So anyway, they go, and so as an artist, I'm going to go to CSAC and I'm going to say, I'm giving you the rights to my work so you can go and collect the royalties for the public performance of my work. That's the basis for that whole system. Now, I am very aware that ASCAP and BMI, the PRs in general, aren't always so polite in their business dealings. People have used the words mafia tactics when explaining this to me. And I think one of the reasons that has happened, a good friend of mine used to be the ASCAP rep for Colorado, Utah, and Wyoming. So his job was to walk into bars and say, you need to pay me. He was a much bigger guy than me. And there's just not a popular, right? Because you feel like I have a restaurant, I have an art gallery, I have this space where, and we play some, we have some speakers up here and we're going to turn on my phone and play some music over Spotify. We're not charging money to, we're just hanging out, whatever. We have an art gallery, whatever it is. And we feel like I shouldn't have to pay for that, but we do. So that's how that all comes about. Each of those PROs have their own licensing schedule, right? And so paying a percentage of ticket sales or paying based on your fire marshal's posted occupancy is all kind of part of that. The tough thing about those organizations is that ultimately they are paying the artists. I mean, what they do is they take 10%, they pay the rest out to the artists. So there is a kind of good behind it, but I absolutely recognize that a lot of times they're not being very polite about it. And that's unfortunately caused a problem.
Is that public knowledge, the 10%?
Oh yeah. All that stuff is, so, well, for ASCAP and BMI, CSAC is private, so it's not a nonprofit, so I'm not sure how transparent CSAC is. But there's a lot of problems with the way that they do things because they cannot feasibly know every song being played in every bar, health club, and elevator in the country. So they have their algorithms for figuring that out. And there's a lot of artists out there who are like, hey, my music's being played on KUNC or the Colorado Sound every day. Why am I not getting big checks? Well, because Colorado Sound is one of thousands of radio stations, and they're only one source of how we collect all our information. So It's just a lot of times artists don't like it either because the algorithms don't work for them. But it is a very...
90% distributed, sorry.
Yeah, 90% distributed to the
It has
artist.
to be distributed every year. And how do they determine? Because again, I know lots of artists that never got the check.
You can also self, like, you can self-report.
Yeah, BMI Live.
And
And,
so is that then on you? That is your liability, because I've heard about that too, where artists are told to report themselves every time they play a set at a club.
Yeah, it's a mix.
part of the great thing, it's maybe my own cynicism, which you're all very aware of now. I actually think that the PROs came up with that because every time that Bree goes and plays in a coffee shop and reports it, BMI goes, oh, we got to get a license from them too. Oh, there's another place that's performing music, another place that's performing music. So it goes both ways. They do calculate all this stuff, but the reality is, if you think about the number of times that a Taylor Swift song is played every day, think about every speaker in this country, every bar, restaurant, right? Compared to the average musician, how much the average album is played in a day, right? And the thing is, how do we calculate this? And so they take radio stations report, I think, twice a year. They get, obviously, reports from Spotify and Pandora and those things. But it is a very imperfect reporting system. So
I think a lot of maybe lawyer legal issues, you're in the now, right? Anything that you might be obsessed with or that you're curious about as far as where technology is taking the creative sector and maybe like a heads up or anything like that. For example, like invoicing, right? Mm-hmm. It's made super easy now, or expressed with like a Square or like Venmo and things like that. So anything that you're like, this is great, but I can see like the devil's advocate or that sort of stuff working out with somebody's augmented reality.
Most of it, right? I mean, it's because the reality is that the digital revolution has changed everything about the creative industries. I mean, especially how we distribute our work, right? And I think there are pros and cons to every single one of them. As far as, what personally kind of gets me interested, it changes day to day. I think that unfortunately, it has been incumbent upon creatives, is made it that much more of a DIY environment because ultimately, I mean, I always say, there's no copyright police. There's no one out there checking to see if someone's stealing your work, it's incumbent upon you to enforce your own rights. And that is frustrating. That can be challenging, and it's that much more challenging with everything out there. So to the extent that we are finding some way to manage that push and pull is really where I hope things are going. But every medium is different. Every vehicle is different. You had your hand up, I'm sorry.
Can you talk about, shifting gears a little bit, can you talk about the process of, let's say, dissolving an existing entity and reforming it as a different type?
Sure. Yeah. Because I definitely have had people who say, well, I may need a corporation down the road, but I just need an LLC right now. It's fine. Keep in mind, they're two separate entities, two separate people. So to the extent you are going to dissolve one entity and create a new one, any obligations or liabilities of the existing entity have to be dealt with before you can dissolve it and hopefully, and apply them to the new one. So that includes your bank account is going to be attached to your tax ID number for that entity, new tax ID number, new entity, new bank account. But also any contracts you have, any ongoing obligations that you have with the old entity, you're going to have to somehow transfer to the new entity because they're separate. The only, and so what I often will have the conversation with the client about what are we trying to accomplish? What's our motivation? Why do we need this entity or that one? And oftentimes there are solutions that are less complex, depending on what we're trying to accomplish. I mean, I have a client who moved to Colorado from North Carolina. They have a Carolina corporation. We were going to dissolve it and move it to Colorado, and we're like, that's a pain. Why are we going to do that? We'll just keep paying. We'll keep paying North Carolina. We'll register in Colorado. We're fine. So after investigating, why are we trying to do this? So it's kind of a case by case. So we actually right around the time when I'm supposed to turn this back over to Meredith and she can tell us where we're going to go have drinks. However, I mean, I know I can speak for myself. I'm probably Dave as well. I am more than happy to hang around and answer questions. We are definitely here for you guys. This is a lot of fun for me to come and have this Q&A and get to hopefully help you guys be better prepared for what you're dealing with in the future. I'll leave a stack of business cards right here in case anyone wants to get in touch. Feel free to shoot me an email, ask me any questions down the road. I'm always happy to talk, but I will hand it back over to Meredith to kind of walk us out and cover whatever else we need to know.